coronavirus pandemic and the extended lockdown has had a clear impact on South Africa's economy and companies, with various government bodies reporting an increase in retrenchment and insolvencies. But under what condition is a company allowed to retrench workers? Thabang Rapuleng, he is an employment practice director at the Cliffe Dekker Hofmeyr employment practice. Thabang is joining us on the line. Good evening, Thabang, and thank you for joining us on Flatten the Curve. The question for you tonight, a suggestion by, not even a suggestion, actually a move by the Labour to say those who are going to benefit from the temporary relief scheme coming from the UIF, those companies whose employees are going to benefit, must make a commitment not to retrench. Is there such an allowance legally, a legal framework that could allow for that suggestion to be possible?
Good evening, Thabo. Thank you for having me. Thabo, I think one can understand where the union is coming from by making such a suggestion. And perhaps one can say that the relief that the companies have received from the UIF will have some effect in delaying or minimizing the impact of retrenchment. But I don't think it can go so far as to say that companies must then make an undertaking not to retrench at all. I doubt whether the companies will be able to do that. And there is nothing in law or the directives or regulations that have been issued by government to that effect.
Now, what we've seen, though, in recent time is a ruling coming from the courts, particularly in the South African Airways matter, where the unions actually took the business rescue practitioners to court to say you cannot retrench people without a business rescue plan. This has obviously, that particular ruling had an impact in terms of the power dynamic. It does seem as though the dynamic that had always been in existence is that a business would make that determination to say, well, we will retrench because it is for the survival of the business. Now the courts are saying you're going to have to present a business rescue plan. That decision to retrench has got to be born out of a business rescue plan. What are the implications of that?
Thabo, that decision, that principle will only apply to companies that are under business rescue. It will not apply generally to all companies. So where companies are not under business rescue, there will not be such a requirement to have a business rescue plan before you can initiate a retrenchment process. So that was applicable for SAA since it was under business rescue, and the union was within its right to challenge the non-compliance with the business rescue requirements. But I don't think that will apply in general to other companies or other sectors.
Now, as an employment director, employment practitioner yourself, what we are seeing now is, for lack of a better word, a jobs bloodbath. Do we have a system or a machinery that is able to handle the magnitude of the type of complaints and referrals that we are going to be getting coming out of this pandemic?
Judging by what we are seeing happening outside the system currently, where we are seeing quite long queues outside the system, one can say that the system is under immense pressure due to the number of authorized that are coming through as a result of the placement and